The concept of fiduciary duty. Under California family law, spouses owe each other a fiduciary duty, which means each spouse owes the other spouse a duty of the highest good faith and fair dealing. Fiduciary duties include the duty to do the following. 1. Disclose all assets and debts. 2. Hold any community property as trustee, which means as a legal administrator. 3. Refrain from taking actions adverse or contrary to the property rights of the other spouse. 4. Exercise due care on affairs and management affecting the community property assets and debts. And 5. Refrain from gross negligence or reckless conduct or any knowing violation of the law. Duty to disclose. A party has to make a full disclosure to the other spouse of all material facts and information on the existence, characterization, and valuation of assets and debts the other party has or may have. Characterization is a legal term which labels the asset or debt community property or separate property. Plus, a party must give equal access to all information, records, and books that pertain to the value and characterization of those assets and debts. From the date of separation to the date of distribution of the asset or debt, the parties have a fiduciary obligation to disclose all activity that affects those assets and liabilities to the other party. Takeaways. In a dissolution proceeding, i.e. divorce, each spouse is in a fiduciary relationship to the other spouse. This means that the spouse owes a duty of utmost good faith and fair dealing to the other spouse. The parties to a divorce owe a fiduciary duty to the other spouse until the assets and debts are divided by an enforceable agreement or court order.